ಹೌದು ಏನು ಮುಂದೆ ಹಚ್ಚಿಟ್ಟು ನೋಡ್ರಿ ಮುಂಜಾನೆ ತೆಗೆದ
You cannot search here in your premises, you cannot miss out. You should have come with the preparation, you should have come with all the information.
This is also
Supreme Court, you are wasting your time.
I beg your pardon.
You can't find the information, search information here.
Just a moment.
No way, this is not expect. If you are unprepared, if you are not prepared, you should not have come over here. Then now,
I think of the clarification number. It is mentioned in the clarification.
you should be here, okay? You should be here. Not in that reading. Go ahead.
Clarification 8 and 9. It is stated that under the social policy, the legislation was passed by the parliament. So it is the legislation, not only the policy. That's why it becomes the law, because it's passed by the legislation of parliament. Clarification number 8 and 9.
You wasted our 10 minutes.
So the council very submission is that the policy is not, it is unreasonable because it fits to Article 14, the reasonable classification phase. This is the maybe 2 or fewer children, and another one is the more than 2 children. So it satisfies the control and the population stabilization. But the restriction imposed is the families with more than 2 children cannot store stem cells at the public and private bank. And however, the treatment is still available to those parents who have more than 2 children. So the inconsistency is the state restricts only preservation. It does not restrict the treatment. And therefore the policy does not actually discourage having than more children. It only arbitrarily restricts a medical facility to preserve the stem cells, and that is where the rational access fails. So the council submission is the objective of the implementing policy is the population control and the population stabilization. Does not restrict the treatment regarding the stem cells. So it not create any impact upon the mind of the parents that if we have more than 2 children, the policy under the children policy we cannot get treatment. They ask the policy.
So what you are expecting? We should strike down the legislation.
No, I am only the council contains the statutory and the constitutional law. The council law your lordship at page number 385 paragraph 23. Justice Lahute explicitly stated that at paragraph 23, a right to make
obligations on the state, but not the unlimited obligations. So, Lordship, also this Apex Code has included Article 21 to create beneficial services to the citizens. Constitutional obligations must be interpreted reasonably. A reasonable interpretation of healthcare obligations under Article 21 consists of resources. The Lordship, the cord blood banking system fails these reasonable tests because it benefits very few people and other alternative treatments exist for the conditions that this stem cell treatment is used to treat. Also, the Union government is providing many of the healthcare schemes such as universal immunization programs, maternal and child healthcare programs, emergency medical services, treating existing diseases that is immediately and preventing eminent threats that are poor treatments like immunization as well as preserving biological material for future existing diseases and prevent eminent threats. But requiring the state to invest in all the preventive measures would be impossible because the state's obligation is to provide reasonable medical treatment and not. In the present case, the Anupam Bliss family contracted with the Sanjivani
The person he was diagnosed with leukemia, that is blood cancer, in 2022 to the diagnosis matters. It is completely vague. In that particular line, I would like to quote a research matters. Please come to page number 7. The stored blood will be used is very low, and the estimates are ranging from 1 in 1,400. And the second one, the very second point in that,
the advances in the conventional treatment and allogenic transplantation means only a few patients with acute leukemia will require autologous transplantation, and if autologous stem cells are required, they could be harvested from bone marrow or peripheral blood. And the third one, the autologous cord, reporting that research, that autologous cord blood is not the best option. For example, pre-leukemic mutant. So there is a danger that even that the collected blood will be having leukemic cells. Highlights that blood can be collected from the cord while the placenta is still in utero or after vaginal delivery or cesarean section. Or the placenta has been delivered. In vivo fertilization may yield larger volumes but could interfere with decide whether the collection takes precedence over some aspect of the mother care, whether the mother or the midwife, the nurse. So that is what is being highlighted. And the third line of the second point, it highlights that collection of cord blood could also interfere with cord blood gas analysis. This is a very important procedure during the pregnancy, mothers. It is
already Moot team.
and also research very
ಅದನ್ನ ಸ್ಟೋರ್ ಕಡೆ ಸ್ಟೋರ್ ಕಡೆ ತೊಗೊಳ್ಕೊ
at birth for potential future use and is not form of any emergency or essential medical treatment. And my lord, I would like to in a similar way I would like to tell that public health policy must prioritize universal health care needs. Policy of rare disease to 2021. Prioritization of treatments based on feasibility and cost effectiveness, where this international law, again this Article 2 of one of International Covenant on Economic, Social, and Cultural.
Permission to address the bench collectively as your lordships. Council on behalf of petitioner has approached this honourable court under Article 32. The petitioner humbly invokes the jurisdiction of honourable.
Who is the petitioner in this case?
Your lordship, we are representing as state.
State. And then respondent is also.
Your lordship, we are acting as a guide to an Supreme Court of Indoria, and here we are acting as an amicus curiae. Indoria under Article 32 of the Constitution of Indoria. As a present case concerned, the enforcement of fundamental right guaranteed under Article 14 and 21 of the Constitution. And I, Council number 1, shall be addressing the bench for 15 minutes with the issue 1 and 2, and my co-counsel will be addressing issue 3 and 4 for the next 15 minutes. If your lordship, indeed your lordships. Your lordship, issue 1 concerns whether the stem cell storage and treatment including umbilical cord blood bank falls within the ambit of essential public health care under Constitution guaranteed under right to health. May it please this court, it is respectfully submission of the petitioner that stem cell preservation and transplantation constitute an essential component of public health care when medically indicated because it satisfies 3 thresholds of the Constitution. They are life-preserving therapies. It is statutorily regulated and medically recognized. Third one, their denial creates structural inequality in survival. My submissions are constitutional recognition of right to health as an infrastructure-based obligation. Your lordship, in the Baramnath Khatara versus Union of India, Union of India 1989, the preservation of human life was declared to be an para. In Pashchim Bengal case, Mazdoor Samiti versus State of West Bengal 1996, 4 SC 37, where the court held that failure to provide an adequate medical facility constitute and violates Article 21.
Do you think that this stem cell therapy is essential?
Indeed, your lordship, it is essential.
Where is it mentioned?
Your lordship, when it comes to an essential public health care, we are considered here as an essential public health care. And we would like to add
Are there any laws or rules regarding the same stating that it is an essential service?
Indeed, Your Lordship, there is an article which says right to health, which says Article 21 which speaks of Article 21 which speaks about human life with human dignity and also the privacy. Article 21 speaks about it. And when it comes to right to health, even it is a part of Article 21 because human who was suffering in the present case, the umbilical cord was not stored of the third child. So I would like to move forward. Your Lordship, in the present case, stem cell transplantation is not an optional luxury treatment, but a life-saving therapy disease such as leukemia, thalassemia, and genetic disorder, which are significantly mentioned in the Moot proposition itself. Therefore, when a medical technology is directly linked to a survival of state's obligation under Article 21, it is extended to assuring that infrastructure that allows reasonable access to such therapies, Your Lordship. The infrastructure dimension of the right to health, Your Lordship. Moving to the second fold, statutory related or speculative medical intervention, Your Lordship. Under Rule 2, Clause W, network. Your Lordship, additionally, in the clinical establishment of minimum standard for the healthcare institution, reinforcing that regulated biomedical facility is a form and part of a recognized public health ecosystem, Your Lordship. Your Lordship, mechanism, it is very important to recognize it as a therapeutic legitimacy and medical necessity, Your Lordship. The therapy is regulated, supervised.
And government of NTC Delhi case in that key holding says that the Supreme Court held that reproductive autonomy is and decisional autonomy are integral to personal liberty and privacy. And another case, Justice K.S. Putaswamy versus Union of India, that also says privacy is a fundamental right. Under these case laws, I would like to say that it is a violation of fundamental right. Yes.
Can you explain how it violates privacy?
See, having two or more child, it's a personal thing of a couple. Government cannot question that. Or government cannot say that to having more than 2 children are not liable for the facilities. But
If you have third child, you must have.
the child, they are denying the medical facilities for a child.
Child has not been born. Who the way to violate the child?
No.
Violation of rights.
They are saying that having more than 2 children, the third child won't get the facilities. They clearly said that.
Tell me, what are the facilities we are talking about?
Self-treatment. They cannot, umbilical self-treatment, they cannot use their own umbilical cells.
Okay.
They cannot preserve it.
Okay. So by not preserving the umbilical cord, the child will not have a treatment.
They have a
Can
treatment.
they use someone else's umbilical
They will
cord?
have definitely, my lord, they will have the treatment by getting the matching. If any other matching umbilical cord is available, then they can have. But it is not available.
Then how it is violated?
In Anupam Dheer case, your lordship, Anupam Dheer died at cost. They haven't been paid.
Anupam Dheer, his umbilical cord was violated. No. So we are talking about the third child. Umbilical cord was never denied. It was not denied, correct? It was his children.
Yeah, third child.
And
Third
he
child.
wanted to use that umbilical cord for his benefit.
Yeah.
That is what has been lost.
Yes, ma'am.
So now, when an unborn child or a third born child, his umbilical cord is not stored, but they can use someone else's umbilical cord. That means there is a treatment available. By stopping what they are doing, they are making space for another family. If I have 10 children and I use all the 10 spaces available in the bank, what happens to the remaining 5 families? Let these 2 child not be
It is not possible, my lord. Why? Because it violates the personal life or.
Law is progressive.
Yeah.
Till we reach that, we need some arrangement in between.
Definitely, my lord.
Two-child norm is a temporary arrangement till we reach the destination.
But it violates fundamental right, my lord. That's why we are requesting to.
That is different. Then I will.
Yeah, you get space to keep their ability. What about their rights?
So that's why
You cannot demand facilities and run away from the responsibility.
Yes.
Tell us what to do.
yes,
You will do.
yes.
So till in the meantime, arrangement.
Thank you for giving me this.
Next, my lord.
All of this already exists. The state brought in a new norm called as the two-child norm, merely to establish their banner of hum do hamare do, and nothing more than that. So this is considered to be medically depriving children, justified, Your Honours, in the opinion of the council. Further, the two-child norm being imposed leaves the individual. They are condemning this stating in the ICMR guidelines of 2023. The state in itself has clearly biological insurance. So people believe it to be insurance in a manner where if they store their stem cell, their life is guaranteed in the future, which is not certain, Your Honours. It depends, it's subjective. But this kind of advertisement often enforces a emotional and economic burden upon the individuals who want to avail that facility, Your Honours. Public allogenic banking, which means that you find a very close match for stem cells, and this is not available in private banks, Your Honours. However, by imposing this particular two-child norm, the child of Mr. Anupam, his third child, did not have access to this, which also led to the death of Mr. Anupam further. And further, it is necessary to understand that it also violates the international human rights obligations of Indonesia under the UNCRC instead of, which wants the children to have the maximum benefit in a manner where their health standards improve. And further, as my co-counsel said, it is necessary that the same is read along with Article 21, Your Honours. And further, since all of these fronts must be structured with an exchange, Your Honours, which Your Honours is the kind of option if you are satisfied with the arguments the council in prosecution. So the next issue is that the judicial intervention is body of marginalized communities. So this is further been classified in such a manner where the first issue that the council wishes to address is that the state has
the right to reproductive autonomy. 96, Your Lordship. 96, Your Lordship. Indeed. Your Lordship, in this para, the court unequivocally held that what is the ambit of reproductive autonomy? What all reproductive autonomy includes in itself. So it said that reproductive autonomy includes right to decide whether to have children, whether it's clearly mentioned in last third line, I have highlighted it, the right to choose number of children. It is respectfully submitted that privacy is a fundamental right under Article 21, which is a settled law. In the case, Putuswamy case, a ninth judgment of this honorable court held that privacy protects one decisional autonomy in the matters such as marriage, family, procreation, and sexual orientation. Your Lordship, it is pertinent to note the observation here. I would like to repeat the considerations of the honorable court in which the decisional privacy is important. The court said marriage, family, procreation, and sexual orientation. To further substantiate my argument, I would like the honorable bench to refer to page number 384 of the petitioner's compendium. Same case Putuswamy. Right to privacy. It says that decisional privacy allows individuals to make decisions about their own by personal autonomy, which prevents state from using citizens as puppets and controlling their body and decisions. Lordship, it's very important. It clearly states that state cannot use this.
Of all forms of inequality, injustice in healthcare is the most shocking and inhuman. Your Ladyship, it is most humbly submitted that the imposition of a two-child norm by the state restricting eligibility criteria for certain rights or benefits. Why it's the fundamental right to life and reproduction provides that no person, I repeat, no person shall be deprived of his life or personal liberty except according to the procedure established by law. You need it on crime offenders. So it is only in cases of crime that Article 21 is suspended by due procedure of law. I ask the question, is having more than 2 children a crime in the Republic of Indonesia? No, Your Ladyship. So, moving on, this Honorable Court has consistently interpreted articles to encompass right to dignity, right to privacy, right to bodily integrity, and reproductive autonomy also. In the case of K.S. Puthuswamy versus Union of India, the jurisprudence of privacy under the judge bench of the Honorable Supreme Court itself unanimously declared right to privacy is a fundamental right. This Honorable Court afterwards observed that privacy includes bodily.
Has the state prohibited your client from having more than one child?
2 children.
More than 2 years? Has it prohibited? Is there a blanket prohibition?
No, Your Ladyship. Could you please clarify more on that?
Violated because the state has prohibited from having more than 2 children.
Your Ladyship, to answer on that very question, which still today have prohibited, all the rules and norms have been mostly related to Article 16 of the Constitution. It was related to public employment or representation of people. It was related to representation of people. Access to essential healthcare services only because of the mere fact that the petitioner has more than 2 children is unjustified in the law.
There is constitutional concern expressed by this Honorable Court in exercising. The Honorable Supreme Court of Indonesia has taken jurisdiction over the present matter through its own vote of cognizance under Article 22 of the Constitution as subject without prejudice to the substantive contention set forth. With the kind permission of Your Honor, if you are well versed in the facts of the case, I will proceed to the state with the issues next. Much obliged, Your Lordships. Your Lordships, it is to be noted that issues 1, 2 and 3 will be dealt by me and issues 4, 5 and 6 will be dealt by co-counsel. The first issue is fall within the ambit of essential public healthcare under the constitutional guarantee of right. It is allowed banking does not fall within the ambit of essential public healthcare under the constitutional guarantee of right. When we are talking about essential healthcare services which are necessary for survival, human dignity, such as primary healthcare, vaccination, maternal care, sanitation, emergency medical treatment, disease prevention programs, etc. This was seen in the case of in-rate distribution of essential commodities and supplies during the pandemic, wherein the Supreme Court took suo motu cognizance and they held that essential commodities and the supply of medicines throughout the nation was the totality of the entire nation. This gives rise to constitutional needs based on universality of need. First. Second one, immediacy of benefit, that is who is benefiting. Third, property like UK, France, US are spending 9 to 10% of their GDP. This clearly shows that if you are providing essential services, it requires the realization of the state and its economic capacity of the state. Thus, realization economic and socio-economic capacity of the state.
The council refers to Ramagaya case, where it was held that no state of any country to spend on any of its projects. That is why it only approves its projects to the extent of citizens. It has to be the extent that finance is permitted. The council respectfully submits that every novel or technologically advanced medical service cannot be claimed under Article 21. But the right to health is indeed broad. It does not translate into every kind of stem cell therapy. To every kind. Stem cell therapy is not classified as an essential healthcare. Which the council has stated. The council also quotes the statement in the Subramania case again. If you could please refer to flashlight number 1, page number 3.
insurances which can be claimed, and even the budget which is the
That's for the affluent class.
We are not here to discuss about insurance.
Insurance.
It's the facility provided by
Provide the healthcare services to the people.
But providing essential public healthcare is different.
So this will be one of the vital therapy which will be very good for the life of the people. That's very costly affair. Only few people can approach the private banks. Can't be afforded by the common people.
But the government is supporting the public hybrid programs, where it's giving 60% of investment in the infrastructure and energy.
Is available for them. This family and the doctrine of proportionality are also satisfied here, my lord. When this doctrine is applied to this particular case, in the present case, the two-child norm implemented to regulate the population, it is with the objective of, on the ground that it is not excessive to the objective behind it. Your lordship,
Why
two-child.
the government can't make awareness?
Many years the government have undertaken various population control measures. We are aware of the National Family Policy during the Indira Gandhi government. They adopted a forced sterilization, but here the government is only establishing or implementing a least intrusive measure, that is establishing a two-child norm based on substantive and elective population control and resource allocation effectively. Your lordship, in the sentence of issue, the reproductive autonomy is not violated here. As held in the verdict of Sujita Srivastava and another versus Chandigarh Administration 2009 case, it has to procreate as well as to abstain from procreating without state interference. But it doesn't impose an obligation on the state to provide premium healthcare service like stem cell storage or and treatment to a third or fourth child on the justification that is parents' reproductive choice. The distinction I want to establish, the council would like to establish here is the reproductive autonomy means states cannot force or compel the abortion or sterilization, forced sterilization.
Why? Because through this policy we are not restricting the right of the citizens to procreate. We are just limiting the allocation of resources, regulating the allocation of resources so that it is available to a larger sections of the society. Similarly, Lordship, if we look at this aspect, reproductive autonomy has to be considered is a fundamental right, which we concede to it, that it is a fundamental right, and policy is not to restrict this right but to stabilize the population and also equitably allocate the resources.
This discrimination is their contention. What do you answer about this?
Lordship, with respect to the child, I submit that this is a very reasonable classification, and this very code in the case of Javed and others was the state of Haryana has very well stated that this policy is not discriminatory at all. But this Lordship, in here we are not violating the fundamental rights. We are just limiting the access to certain welfare benefits and limiting the access to certain welfare benefits with the aim to equitably allow these resources, the limited resources.
Please,
When the state acts in a way that violates the very fundamental rights that the citizens possess, judicial review becomes a constitutional duty of this very court. Thank you, Your Honor.
Not submitted. Huh? Start.
Yes, so
but it is not related to financial condition of the state.
no, but it is why it is put in the directive principle. That is the consequence because it is depends on the state resource allocations.
What is this? You just give the last.
Then according to you, Article 21 also related to directive principles. Right to life comes under Article 47, not under Article 21.
No, I am not saying that. The
It says intoxicating drugs and main problem issue is regarding the STEM culture. Okay.
Yes.
On that, where does this article covers that?
No, it is the stem cell therapy. These drugs is not related to stem cell therapy. This is the intoxicants.
So the answer, let's say, Article 47 will not help you.
It will not help you.
I am not only contending regarding Article 27. I am contending regarding the directive principles. Just I give an example of the Article 47.
Carry on.
As well as lordship, the public health and sanitation is comes under the state law. Part 2nd, entry 6, under Schedule 7. So the union government.
Income disparity has increased, and because of the income disparity, there are many people who do not have that economic resource are expiring slowly because of other reasons. So you yourself are accepting that all of these problems have been present over there. What have you done to tackle such issues? As a state, it is your responsibility to look after its own citizens. So as a state, what measures have you taken to come out of this economic disparity and create a socio-economic,
Based power blood biotics and regulate framework for the medical technologies. So, by these provided by the state, already it is provided, then there is no question.
To embark upon an inquiry as to whether a particular public policy is wise or different policy would have been created or wiser or more scientific or more fortunate. And that's of this nature. We say if you've enacted a policy, unless and until it's way too arbitrary that it interferes, we not make it.
The situation warrants such a big intervention by this honorable court when we have far more important matters concerned is something we should have to take deep cognizance of, my lords. And very most importantly, my lords, the context of this case, or be it the Balco judgment, or be it the Balco judgment, my lords, it was all under emergency medical treatment. My lords, as my co-counsel had already pointed out, primary healthcare sectors in your area, we give, and my lords, we have even enacted the Pradhan Mantri Jan Aushadhi Yojana, whereby you get generic medicines at lower cost. All of these exist for you. And my lords, and all of these are an absolute evidence that we follow Article 21 and we have utmost respect for this honorable court's dictum laid in Paschim Banga and Parmanand Katara, whereby right to health will include essential healthcare services. And And by essential, will it include all advanced medical directives or all advancements in medical systems? Already pointed out, the cost of everything has to be taken into account, my lords. We will run bankrupt. We will run absolutely bankrupt, my lords, because the whole point of this umbilical cord preservation can only be done at your birth. If you
qualifying to the pre-quarterfinal round. So let me start with the attendance just to see that all the teams are here when I tell you the rules. Team code 27, please raise your hand if you are here. 27, 1, 15, 15 is not there, 11, 18, 4, 17, 17 is not there, 13, 21, 21 is not there, 10, 3, 29, 29 is not there, 25, 20, 21, yes, 21. 21 is here, 17 is here, so 15, 1, 5, 15. So now onwards it will be a knockout round. In every court hall, one team will win and the other team will get disqualified. So here, I hope you have seen the rules regarding pre-quarterfinal round. Suppose in pre-quarterfinal round there is a tie between both the teams as far as scores are concerned. Your memorial marks will not be considered to decide who is going to qualify. We will be seeing which mooter has got the highest marks. The mooter scores will be considered to break the tie. See, again you may think why tie? Because two judges are going to judge. They may give you individual marks, but when we total them, there can still be a tie. So that is why at that instance, who gets the highest
Pin code 70. On number 5.
Your Lordships, the Council 1 will be dealing with issues 1 and 2, while Council 2 will be dealing with issues 3 and 4. Your Lordship and Ladyship falls under the ambit of essential public health care under the protection of Article 21. The Council humbly pleads to 1 will deal with the essential nature of the healthcare itself, and 4.2 shall be deal with the harmonious interpretation between DPSPs and fundamental rights. Your Lordship, this Honourable Court has consistently, on multiple instances, has derived and demonstrated that right to life includes the right to live with the life-saving medical treatment. Your Lordship, Article 21 in regards to life health must evolve with changing medical advancement in medical sciences, and compendium submitted, which talks about the case of Maneka Gandhi versus Union of India. The court held that fundamental right should receive a liberal and purposive interpretation. In reference to page 4 of the compendium submitted, the court held that the right to life includes the right to health, which also encompasses the right to medical essentiality, shall deal with whether if the deprivation of such healthcare services will lead to the result in the loss of life. It should not depend on 1. Novelty, 2. Cost, and 3. Technology. Ergo, the Council for the Petitioners humbly submit that, apologies Your Lordship, by applying the settled principle, umbilical cord blood stem cell therapy is used in the treatment of life-threatening diseases.
Essential healthcare must be interpreted not merely as minimal or basic care, but as treatment services necessary to preserve life and ensure equitable access to modern medical treatment. Your Honour, the concept of essential healthcare cannot remain static. In Navtesh Singh Johar versus Union of India, it reinforces the doctrine of transformative constitutionalism. Medical science evolves rapidly, and treatments that were once considered extremely inaccessible and expensive are a clear example of this evolution is seen through the HIV/AIDS Prevention and Control Act of 2017. It is statutory protection ensuring access to this treatment. Stem cell therapy represents a comparable medical advancement, transforming
You cannot compare this particular stem cell preservation method with AIDS, because AIDS, you cannot compare treatment for AIDS and in preserving stem cell umbilical cord, because AIDS you are targeting only one disease class, specific disease. Here there are many possibilities that are still evolving, emerging. There are many researches going on throughout the world. And second is, it is very expensive treatment. So how do you propose to overcome the
So 1.4 billion people into the amount that you are saying for each year, and they may require it or may not require it. Even presuming that 0.001% of the population may need it, are we equipped to handle such an expansion of what you are stating?
Your Lordship,
And he says that I want this, my own child's umbilical stem. So for 35 years, the government has to maintain it with the question that he might need it. Whenever the terminology might or a scenario might arises, that is a luxury. That does not come under regular healthcare services. the luxurious thing that you are asking right now is also an experimental.
To your lordship, the facts themselves have mentioned that it is an established public healthcare. The only question here is whether or not it is essential, your lordship.
Yes.
So, in case the state contends or wants to say that they do not have enough resources to sustain this proposed plan, it cannot really make an excuse, your lordship, there when we have a case law, your lordship. And also in many other case laws, they have said that the state cannot see that resource constraint is an excuse to not give the necessities needed for the public, your lordship. While we evaluate the concerns of the state, that is why we have suggested a phased implementation. We are empathetic towards the state and its resources, and that is why we have asked for a phased implementation.
I just wrap up in 1 minute. Just 1 minute.
Council seeks time permission, now seeks permission to address issues number 3 and 4. Much obliged, Your Honor. Your Honor, under issue number 3, the Council shall argue on how the youth child law violates the right to life and reproductive autonomy under Article 21 of the Constitution of India, Your Honor. And with respect to this, the argument is considered to be threefold, and the third child of Mr. Anupam Reed in a manner where it is applied in order to deny her access to the public court banking system, Your Honor. So it is humbly submitted before this honorable court that the third child of Mr. Anupam and Mrs. Kiran was denied access to the public court banking system, but was also denied her right to life merely because she was born third. The only right bank at the time of the birth of the child is one of the banks where the government holds around 60% of the ownership, Your Honor. So this being the particular government, and also where there is substantial investment made by the government, very much forms a part of state within the meaning of Article 12, and there which is held at every state instrumentality in agency, although it may have been formed as a private body, forms the state within the meaning of Article 12. The government holds deep and pervasive control over it. So therefore, the act of stem cell inquiry to refugee storage is that every child has a separate legal entity, and every child has protection under Article 21 respectively. However, the state has failed to
stem cell therapy is a beneficial and an essential life care services, because we have seen transplants all come under the ambit of essential stem cell treatment at the end of the day, and that is why we request this honorable court to issue proper guidelines to the state if it may deem fit assist to that.
Is it in our domain?
Your lordship, as I previously
Allocation of what is exclusive in the domain of the legislature and the executive.
Your lordship,
Don't you think you are forcing us to step in the domain of the executive?
I understand your concern, your lordship, and that is what the council is trying to plead. If the judiciary can issue guidelines to the state to form proper documents, proper policies in which there is a separation of powers, but still, as I mentioned in the case of Vishakhapatnam State of Rajasthan, which finally it helped in curbing the executive vacuum, and hence we came to the regulations of Post Act. Whereas if I would like to request this honorable court, plead in front of this honorable court, if they can issue such guidelines that can assure that can take an assurance from the state, if they can provide policies that can benefit people who require stem cell therapy and provide access to them, something that.
So that is your petition is entertained, tomorrow someone will come and force us to allocate more funds for this sector, for that sector.
Your Lordship, in COVID-19 pandemic, that immunization from such vaccines could actually save the life. Oxygen supplies, essential drugs like remdesivir were created a task force for verifying whether such oxygen supplies are in the adequate amount or not, whether the price of vaccines is up. Similarly, in Master Arnesh Shaw versus Union of India, the court recognized that medical interventions are indeed complex in nature and set up a committee. Access to diseases, access to cures for diseases which are chronic in nature and the cures which are more prevalent in children. And if the children of the country are left to die, then the future of the country will be in stake as well. Hence, the contention of your bench, hence the contention of the honorable bench that the honorable court is already agrees with it, categorically agrees with it. But it is the responsibility of the honorable court as well to ensure that when such injustice is being done to population at large.
There, in the light of facts, circumstances and submissions made hereinafter, it is most respectfully praised that this Honorable Supreme Court of India may be pleased to declare that access to life-saving cell storage and treatment, including umbilical cord, blood banking, forms an integral part of right to health under Article 21 of and to hold that Article 21 can be invoked to claim access to stem cell therapy, irrespective of whether such treatment is formally classified as essential public health care by the state, healthcare benefits and life-saving medical facilities. It is unconstitutional and violates the Article 14 and 21 of the Constitution of India. Direct the Union of India to formulate and implement a comprehensive, equitable and accessible public policy framework for umbilical cord blood banking and stem cell therapy, ensuring non-discriminatory access to all the citizens, particularly economically weaker sections.
The whole policy for preservation of the stem cell only for the third child, and the reason for this is the two-child norm. When Anupamji later required this for this stem cell for the purpose of leukemia, there was he couldn't get anything because the first one was with the private sector, and in the private sector, which was kept in 2005, he had spent almost 5 lakhs in the 7,50,000 in the beginning, and again 1 lakh each as a maintenance for 5 years, even 7,50,000 plus 5 lakh each, but he couldn't use that because in 2022 when he requests exactly that, they asked for 2 crores rupees your option. The reason here is they charge almost, I would like to provide with the calculation, they charged a lordship almost 45% of interest your lordship on that. And with regards to the second child,
arranging the interest rate.
Interest rate, the amount which is paid should not be arbitrary. Competition also should not also considered, and it's a essential healthcare services.
Congratulate all the teams, 8 teams for qualifying to the quarterfinal round. Just check. Yes, let's have attendance. 1, team code 4, 13, 20, team code 21, team code 27. 2021.
Team code
1 team is going to win and the other team is going to get disqualified in each court round. The rules of pre-quarterfinals and quarterfinals are the same. That is, memorial marks will not be considered as it is a knockout round. In case of tie also, memorial marks will not be considered. In case of tie, to decide who is the winner, first option will be among both the teams, the
1, respondent. Team code 1, code call number 1, respondent. Team code number 4. Team code number 4. Code call number 4, petitioner. Code call number 4, petitioner. Team code number 11. Team code number 11. Code call number 1, petitioner. Team code call number 1, petitioner. Next, team code number. Team code number 13. Code call number 4, respondent. Code call number 4, respondent. Next, team code. Code call number 2, respondent. Code call number 2, respondent. Code number 14. Code call number 2, petitioner. Code call number 2, petitioner. 41. Code call number 3, respondent. Code call number 3, respondent. 27. Take code number 27.
Code 1, respondent. You can come for exchange of memorials. Team Team code 20, code 15, respondent. Code call number 3, team code 27, petitioner, team code 21, respondent. 27 petitioner, 21 respondent. Code call number 4, team code 4 petitioner, team code 13 respondent. 4 petitioner, 13 respondent. Final will be tomorrow. The 3-day schedule is there in your group. Kindly adhere to the timings because we have to finish quarterfinals, semi-finals and then finals, ending up with valedictory in the whole day. So now there is a culture. At least you need some half an hour to 1 hour of recreation, relaxation of your mind. So kindly go to the auditorium and enjoy the cultural program. Our college.
Judicial activism is derogatory term when it comes to judiciary because they believe, people believe that judiciary is actually beyond this scope. But what is protection of protecting fundamental rights, as it was envisioned by Montesquieu when it laid down the doctrine of separation of powers, and it said that the judicial activism is derogatory. That is what the media and the executive is trying to portray. But however, what I believe. That's why I said overreach. Overreach is